Welcome everyone. I think we've got enough people in the room now to start. So welcome to this afternoon's webinar on reviewing voluntary assisted dying in Victoria, which is being jointly hosted by Palliative Care South Australia and COTA SA. My name is Nick Muirhead. I'm a board member of Palliative Care SA, and in my other life, I'm a lawyer with Norman Waterhouse Lawyers in Adelaide, and I'll be your moderator for this webinar. Firstly, I would like to acknowledge the lands that you are meeting on in Adelaide are the lands of the Kaurna people. In Melbourne, where our presenter, Justice Betty King, is, we recognise the Boon Wurrung and Wurundjeri Woi Wurrung peoples of the Eastern Kulin Nation as the traditional custodians of the land. Further, we uphold the cultural authority of all Aboriginal and Torres Strait Islander peoples who may be participating in this webinar. Thank you also to some of our more prestigious guests that are joining us today. We acknowledge our parliamentary friends, the Honourable Kyan Ma, who of course introduced our VAD bill in SA, and the Honourable Dr. Susan Close. Betty, I'd like to start with a personal note that we offer our thoughts to you and all Melburnians for your, as you tolerate your fourth lockdown, I believe it is. And a quick note to everyone present that we're recording this afternoon's session and we'll be putting it up on our website once it becomes available. So to really kick things off, this is the third and last of our series of webinars focused upon the Voluntary Assisted Dying Bill in South Australia. The first one, held at the end of March, explored the specifics of the private members bill tabled by the Honourable Kyan Ma, MLC, in the South Australian Parliament on December the 2nd of 2020. The second session, held in April, explored the clinical experience in Victoria. This allowed a range of views from medical practitioners, as well as a hearing from a VAD navigator. The people involved were Dr. Leroy William, the President of the Australian-New Zealand Society for Palliative Medicine, and an adjunct associate professor with Eastern Health, Melbourne. Ms. Susan Jury, a clinical nurse consultant working as a VAD care navigator, and Dr. Greg Newitt, a specialist palliative care physician who has been a conscientious provider of VAD. My organisation, Palliative Care South Australia, has three clear positions in relation to voluntary assisted dying. Firstly, that we remain neutral on the topic from a political perspective. Secondly, we have consistently argued that palliative care needs to be resourced effectively and equitably across the state so that people's choices are freely made in a context where they have experienced the full gamut of pain relief and comfort care that should be available. This was highlighted in the End of Life Choices report tabled in SA Parliament on the 13th of October last year. Thirdly, PCSA knows it's important for us all to talk about this topic in the public domain and that we need to be part of the conversation. To this end, we will continue to work to create suitable opportunities to share information and opinions regarding VAD. And to provide a quick update on the progress of the South Australian VAD bill, as many of you will be aware, the draft bill passed the Legislative Council on May 5th, and last Wednesday, in the second reading of the House of Assembly, it passed again. This means that it's now progressed into the committee stage where amendments may be proposed and debated. The committee discussion is slated in the lower house for the coming 9th of June, after which it can come back into Parliament for the third reading and debate. The draft legislation in South Australia is very much based upon the Victorian legislation, and therefore today we are taking a look at how the legislation is reviewed in Victoria. In just a moment, I'll introduce our presenter, Justice Betty King, to you. But firstly, I'd just like to pause for a moment to make sure that you can all see and use the question and answer systems in the chat line, the functions on your screen. At the end of Betty's session today, we hope to allow at least 20 minutes for you to ask questions. So please, I'd appreciate if some of you could practice now and send a greeting through to me on the chat line so that you know how to register questions. You might want to include how you're feeling this evening and what you want to get out of today's session as an icebreaker. Can you see any questions? Right, I may be the only one that can't see them, but I've got people here to help with that. So I now have the sincere pleasure to introduce our presenter for today, former Justice Betty King of the Victorian Supreme Court, or simply Betty, as she's asked that we refer to her for today's purposes. To give a bit of a highlight recap of Betty's career, in 1975, Betty signed the Victorian Roll of Counsel, making her, I believe, only the 24th female barrister to do so. In 86, she was appointed the first female Crown Prosecutor for the state of Victoria. And then in 89, was appointed first Prosecutor of the Commonwealth for a couple of years. In 92, she was appointed Queen's Counsel for the state of Victoria. And in 93, became the first female member of the National Crime Authority, a role she held until August of 95. From 95 until 2000, I understand Betty took briefs as a Queen's Counsel of the Victorian Bar. And in 2000, Betty was appointed a judge of the County Court of Victoria. And subsequently in 2005, Betty was appointed a Justice of the Supreme Court of Victoria, a role in which she served for about 10 years until her retirement from that role in 2015. What Betty is maybe unfortunately most well known for from her time on the Supreme Court is for banning the original TV series Underbelly in Victoria and running the gangland trial, sentencing Carl Williams for his crimes. Betty also presided over the tomato tins case involving a Griffith, New South Wales, I believe, based cell of the Calabrian Mafia and their importation of 5 million ecstasy tablets via a container of tomato tins from Calabria into Melbourne. Since her retirement, returning to Betty, Betty has kept herself busy, I believe, as both an appointed member of the Board of Victorian Legal Aid up until last year, and as the inaugural chair since June of 2018 of the Voluntary Assisted Dying Review Board, which of course is what brings her to us today. And without further ado, I'd now like to hand over to Betty.
Thank you very much. It's not really possible for me to give a lengthy overview of how the Victorian Voluntary Assisted Dying legislation has been set up or how it works, but I will try and provide a short version. So there is a Voluntary Assisted Dying Review Board. I am the chair. As you heard, I'm a retired Supreme Court judge who specialised in criminal law. We have a total of 13 board members, and they include an oncologist, an intensivist, a registered nurse who has been involved in palliative care and death literacy, a neurologist, a palliative care physician, a former professor of nursing specialising in palliative care, a pharmacist, a respiratory physician, a general practitioner, and another lawyer, this one specialising in personal injury, a layperson, and also some of those people have been also consumers. That is, people who've cared for loved ones who have died and have utilised palliative care services. It's a good mixture, and let me assure you, they're all very willing to speak their mind. These people were selected by the Minister for Health to be the initial board members, and we will be the board for 6 years. So what do we do as a board? When you distill all our functions and powers into areas, there are 4 major areas that the board deal with. The first, ensuring compliance with the Act. In this area is the review and referral process. That is, referral for breaches of the Act to either police, APRA, the coroner, birth tests and marriages, or the Secretary of the Department of Health. The review function can lead to referrals. The second is providing information and reports to the Parliament, Minister, Secretary, health practitioners, and very importantly, the community at large. The first 2 years we reported every 6 months, and from this point on we will report annually. As we have more cases, we are able to provide more information without the risk of identifying any of the participants in the actual process. The third role is ensuring the quality of the process and providing recommendations for improvements to any part of the VAD process. We will have a review, it's in the Act, at the end of 5 years. In the fifth year, there will be, sorry, the end of 4 years. In the fifth year, there will be a review, and that will look at all of the things that could be improved and refined in relation to the legislation. The fourth task and role is the collection of data and research in respect of VAD. So the big question is, how do we do that? How do we actually ensure compliance and voluntariness, which are the two issues that most people seem to be concerned about? What we've done is we've established an online VAD portal, and that's the only platform through which the voluntary assisted dying forms and permit applications can be completed and submitted to the Voluntary Assisted Dying Review Board. The portal is for medical practitioners as well as the staff of the Secretariat, and it was designed to ensure that the forms couldn't be altered or tampered with during the process by anyone other than the practitioner and would-be note. As we have progressed, we have noticed and become aware of issues within the portal that were not anticipated, and we're actually in the process of significant portal amendments. The fundamentals that I'm describing will not change, but there are several things we believe we can do that will improve the portal and its ease of use. To do this, we consulted with medical practitioners involved with the VAD process in a number of different ways, including we had group online discussions with them and the persons responsible for the design of the portal, surveys to all practitioners, group discussions with staff from the Secretariat, as well as other means to try and ensure that the portal reflects what the practitioners, the applicants, and those involved in overseeing the Act need. So what we're attempting to do is trying to make it as user-friendly and intuitive as we can make it within the confines of the legislation. The process required to comply with the Act is extremely detailed, and it is this detail and the comprehensive information requirements that provide so many of the key safeguards for the public in relation to abuse of this process. The legislation requires the submission of a number of forms to the board, all of which are set out in full detail within the Act itself. So not something that we get to choose, but what the Parliament has chosen. And they proceed in this manner. Form 1, the coordinating medical practitioner undertakes the first assessment, and they must certify that the applicant meets all of the requirements for eligibility, which include that the person is over 18, that they're acting voluntarily and without coercion, and that they understand the following matters: the diagnosis and prognosis of their illness, the other ongoing options that are available to that person, including palliative care options and the likely outcome of those options, that they need to understand that they can discontinue voluntary assisted dying at any time and do not have to persist with it, the risks also an outcome associated with the consequences really of taking the prescribed substance. The practitioners must also cite and upload documents that substantiate the applicant's eligibility via proof of citizenship or permanent residency, together with materials that demonstrate the applicant is a Victorian resident and has been ordinarily resident in Victoria for the last 12 months. The last is really designed by the Parliament to ensure that there is no, what was called death tourism. That is, people flying in from other countries or other places. Form 2 is one prepared by what is referred to as the consulting medical practitioner. They undertake a separate assessment, and that assessment must be provided in the form to the board and to the coordinating medical practitioner. The consultant must independently provide all of the same information and certify the same matters that I've just referred to in relation to the coordinating practitioner. Both medical practitioners must be fellows of a college, and at least one of them must be 5 years post-fellowship and one must also be a specialist in the applicant's illness or disease. So they're the first two independent doctors looking at the applicant, talking to them face to face, and in most cases these consultations take quite some time. Form 3 is the next, and that is the written declaration. The coordinating medical practitioner must be present and witness the applicant's written declaration. This form must be signed by the applicant in the presence of the coordinating practitioner and 2 other people who, as well as witnessing the applicant sign the form, also certify by their signing that the applicant was making the declaration voluntarily, without coercion, and that the applicant understood the nature and effect of what they were signing. Only one person, in terms of a witness, may be a family member, but no one who is a beneficiary under the applicant's will or who may otherwise benefit financially is eligible to be a witness. The same applies to any owner of any facility treating or caring for the applicant, or those who are directly involved in the applicant's healthcare. There is also then a further final request that must be made by the applicant as separate from the written declaration, and that's an oral request. Form 3 must be signed first, and often the final request is then made and Form 4 is signed. That may all occur on the one day, but there must be 9 days between the first request and the final request as a minimum, unless there are some urgent reasons why that should be shortened, and both doctors would have to certify that it needs to be shortened from less than 9 days. Form 4 is the document that is signed after the oral request is made, and that is, once that final request has been made, the applicant must appoint a contact person. That person is responsible for the return of any unused substance if the applicant does not consume it all, or if the applicant changes their mind, decides not to proceed with VAD after the substance has been dispensed, or loses mental capacity, competency, or dies before being able to consume the substance. Form 5 is the next document. It's a final review where all of the previous documents are attached and the coordinating practitioner goes through all of the steps and certifies again that each of those steps and requirements has been completed and fulfilled to their satisfaction. Copies of those forms can then be provided to the Secretary of the Department of Health with an application for a voluntary assisted dying permit. If a permit is granted, then the applicants can seek dispensing of the substance. That's where Form 6 comes in. This is the VAD substance dispensing form. Once a permit is granted, the coordinating medical practitioner can then contact the pharmacy and the applicant and inform them that they have a permit. The pharmacy will also be automatically notified via the portal. And if and when the patient requires the substance to be dispensed, the applicant must contact the pharmacy and request the substance to be dispensed. A date will be arranged and two pharmacists will in fact take the substance to the applicant wherever that person may be located in Victoria. The 2 pharmacists will then again assess whether the person is competent to understand the information that is required to be provided by the pharmacists and whether the person is capable of accepting and swallowing the substance. The 2 pharmacists will explain the process to the applicant and usually the applicant's family, and will do a dry run of mixing the substance. This often takes upwards of 2 hours with the applicant and their family. If they are not capable or competent, the substance will not be dispensed. If they cannot swallow, the substance will not be dispensed. If the substance is dispensed, Form 6 is completed and lodged in the portal, recording the date and place of the dispensing. If the applicant does not, in fact, take the medication, the substance, doesn't use it, then the statewide pharmacy service must also provide a substance disposal form, being Form 7, when any medication is returned. The board must then provide a copy to the Secretary of the Department of Health. If there is leftover medication, the obligation is on the contact person to contact the statewide pharmacy service and inform them of this within 14 days of the death of the applicant. The pharmacy will then arrange for a pharmacist to go and retrieve that substance from the contact person. Once again, no matter where the person is located. There is practitioner administration available in respect of voluntary assisted dying, but there must be a medical reason why the applicant cannot consume the medication. And if so, then there would be a practitioner administration form completed, which would be Form 8. Applications for voluntary assisted dying permits are approved and rejected by the Secretary of the Department of Health, not the Voluntary Assisted Dying Review Board. The decision of the Secretary is based upon the documents provided to the board during the process of application. The Secretariat to the board receives and checks each of the forms for any obvious errors or omissions and liaises with the coordinating medical practitioner to try and correct any minor matters. If the form is non-compliant, that is, there is something wrong within it, the Secretariat will recommend that changes be made to the form by the coordinating or consulting medical practitioner to make the form accurate and compliant. It's a matter for that particular practitioner whether they accept that advice. They usually do, but occasionally one will push ahead with the application without making the recommended changes. That is their right. An example of such non-compliance that might be pointed out would be something such as a failure to provide proof of citizenship or permanent residency of the applicant. All the forms up to and including Form 5 must be provided to the Secretary of the Department of Health, who, if he or she grants the permit, will also lodge that permit form on the electronic portal. As can be seen, many different people play a part in this process, and that is why it was determined that it was essential there be only one way in which the forms can be lodged, and that was electronically via the online portal. The portal also permits the medical practitioner to complete, sign and submit the forms electronically. All acknowledgements are electronic and allows the user to apply for a permit, receive notification of the outcome of the permit application, view and print the medication protocol and the prescriptions. They can be downloaded, printed and filed. Unfortunately, there is still the aspect of that the applicant and the witnesses must sign those documents, being Forms 3 and 4, as physical pieces of paper, and they then must be uploaded into the portal, which is one of the issues, I'm sure, for practitioners in terms of trying to upload numerous documents. But it is a requirement under the Act that it be signed by the applicant in person and witnessed by these people, independent people. Now, the board reviews every instance in which a person accesses voluntary assisted dying. The board members receive and can access, but of course not alter, all of the forms set out in the schedule to the Act. The board also receives information about death notifications and feedback from different people. The board reviews the whole of the application after the application has been completed by the death of the applicant. That includes cases where the applicant has died because of their illness rather than consuming the VAD substance, if they've been granted a VAD permit, or have appointed a contact person but not yet been granted a permit, and what we refer to as withdrawn cases, where people have died before being able to obtain the substance. We examine the documents for compliance issues such as eligibility criteria, citizenship, residency, etc. Qualification requirements of medical practitioners. We examine each form to ensure compliance. Things such as that signatures were properly witnessed. We also look for problems we can see arising as to things such as accessibility for applicants. What processes seem to be difficult? How can things be improved? In our review document, we have a column headed Learnings, and each board member reviewing the case can make a comment in that column or any other column in the document. The board experience is that the process is painstaking and difficult. The assessments by the medical practitioners take a significant period. They must be done in person, and the applicants are often very unwell, and having to travel is for some of them an absolute ordeal. Telehealth is not capable of being utilised currently as the Commonwealth will not, despite requests from the Minister for Health, amend its legislation to exclude lawfully enacted voluntary assisted dying legislation from the definition of suicide in the Commonwealth Criminal Code relating to the use of carriage services for suicide. Hopefully in the future, some common sense will prevail and the wishes of the public of Australia will not necessarily be thwarted by a piece of legislation that was originally designed to prevent Dr. Philip Nitsky advising people online how to commit suicide. That's a matter ultimately for the politicians. The board is also privileged to see the contents of the feedback provided by the nominated contact persons and medical practitioners. In each case, whether the applicant utilised the VAD substance or not, a member of the Secretariat, in what must be a very difficult task for all involved, will contact that person or try to contact that person and obtain a time at which they'd be willing to provide some feedback. Many people do in fact provide the feedback, which is incredibly useful and informative. Medical practitioners have also sent an email feedback form for each case. And although the response to this is less frequent than the response by the contact person, once again, it is especially useful in providing information on what we are doing wrong as well as what we are doing right. Some people talk about the burden of the process, the applicant having to repeat so many times that, yes, they really do want VAD. The difficulty they find sometimes in finding information about accessing it. The problem with the medical practitioners not being able to inform or raise the topic. But more importantly, so many talk about the peaceful, calm or dignified death of their loved one, partner or friend. They also talk about the peace of mind that receiving the permit or the substance provided to the applicant, whether it is used or not. Occasionally, there are stories of frustration at the process being so difficult. But in the main, the comments are about their loved ones ending their life in the way they wanted to. Not in pain, gasping for breath, as sometimes they have witnessed with other family deaths or members or friends. I should say this is still a learning process for all of us involved in VAD. A member of the board. We were the first to do this legislation and somebody had to be first. If the Government of South Australia do in fact bring in the VAD legislation and it goes through, receives assent, then I hope that you would be willing to utilise Victoria's experience. We'd be only too happy to share with the people of South Australia the background, the information and the things that we've noticed over the time to try and make the road for each of these persons seeking to utilise the service easier. Hopefully this has explained a little bit about how the actual process works and the safeguards that are built into the Act and the process. I'm happy to answer any questions you may have about it.
Thank you very much, Betty. It's been a privilege. As we've been promising, we're now going to open up this webinar to your questions. Please note, if you want to ask any questions that we don't manage to address today or talk to, we'll try to respond following the webinar. I'm going to start with two questions that I think have come in through the chat line so far in the session. If you could speak to this, Betty. It's an interesting question, the first one, I think, on how you respond to it. But Steve Mills has asked, he would like any help to understand how spiritual care can help patients that are seeking voluntary assisted dying.
I would have thought anyone who is terminally ill would probably be enormously assisted by spiritual care, whether they're going through the VAD process or the palliative care process. It's a traumatic time for them and their family.
Peter Jenkin has asked what happens when a person who has motor neuron disease or a similar condition that makes signing physically impossible, but they do have mental capacity to make the decision. How is that situation approached?
Someone can sign on behalf of the person, but there needs to be two people plus the medical practitioner present who observe that the applicant has asked the other person to sign on their behalf, be it via words, writing on a board, just anything that indicates that they want this to happen, and the person signs on their behalf and the other people witness that that's been done. Equally, if you can no longer write, you can show your assent to many things just by either nodding or whatever form of communication you have.
Thank you, Betty. And we've had a further question, which I'm tempted to try and answer for you, but I'll leave it to you. How can you be assured that the request is voluntary?
Through the processes I've just been talking about, if you add it all up, then you've got, first of all, two medical practitioners independent of each other who have ascertained and tested for themselves that the applicant is making this voluntarily, not under coercion. You've got two witnesses who document that they have seen the person signing voluntarily, making the request for the declaration that this is what I want. You have two pharmacists who assess. That's a fair lot of people to convince that if you're trying to do it over a lengthy period of time, that under duress.
Yeah, I thought by the time we got to Form 8 or 9, it was starting to become obvious the level of bureaucracy that's there to try and safeguard that.
Well, it is a difficult and onerous process, but that's the safeguard that's been brought in. It's quite interesting, the experience we have from the board is that family members, more than trying to convince them to use it, try to convince them to not use it because they really don't want to lose their loved ones.
And we've had a further question as to maybe if you could just speak to, I don't know if I'm sure you may have encountered this, but there's been a lot of discussion in Adelaide today about the concept of institutional conscientious objection. I understand, as the commenters noted, that the Victorian legislation was silent on that. Can we ask for your views on whether an institution should be?
Victorian is, I have to say, I don't know that an institution really should have the right to dictate to anyone. Individuals certainly should never be compelled to do anything that they do not wish to do. I have no problem at all with that. But you take an example that if someone's associated with a palliative care organisation that is faith-based in some way, the organisation itself can then dictate to all of the people who work there, who might have quite different conscientious views. Some may be supportive, some may be opposed, but they're then imposing their views upon those who work for them. It doesn't seem to sit right.
We've had a few more questions on that point, but I think I'll move on. Once the voluntary assisted dying process commences, we've had a question from Sally Cockburn about, can the palliative care process continue, or is there to some extent one overrides the other, I assume, or excludes the other?
No. Can I tell you that almost our experience is that 90% of our applicants are involved with palliative care right up to and including the moment they take their medication. They're not exclusive. They are supportive of each other in that it's just all about assisting a person to deal with the terminal phase of their life in the best way possible. And the palliative care services are terrific. They do a great job. They provide so much help, and they do it for most people involved in VAD. We have some faith-based problems in relation to, and so be it if you're a conscientious objector, so that's fine. But most of the times, palliative care services have been involved and wonderful with the VAD participants.
Thanks, Betty. Penny Fire has asked if you have what the requirements or standards are for interpreters and what's required from applicants in that regard. i.e. if there's no family who can interpret, must there be an independent certified interpreter?
Yes, there must. There must. Family cannot interpret for someone who requires an interpreter under the Act. It must be, this is in respect of witnessing forms or signing forms, making oral requests. That must be a NAATI qualified interpreter.
Sorry, there's been quite a few questions, which is great.
Oh, good. I'm here to try and help.
I'll just read the question verbatim, because I'm not sure I understand it exactly. What are the issues, Sarah M asks, surrounding using voluntary assisted dying in a patient selected location? Is it dictated where it must be used, or could some go to the beach and use the process, for an example?
The process is such that the substance is dispensed to the patient. So the patient can take it to the beach, holiday house in the hills, anywhere they want, and take the substance. A lot of ours take it home, surrounded by family, music playing, with lots of hugs and goodbyes.
And we've got a question from Greg Crawford. Do you have any insights or comments to offer about conscientious objections for individuals and organisations and how that's been managed in Victoria?
People totally have the right, as I said, to be conscientious objectors and not participate. A lot of the faith-based organisations have in fact drawn up policies and plans about not supporting but not impeding. And that is referring on. We have, you actually had one of them last time, care navigators in Victoria, and they are amazing people. The feedback we get about the care navigators is extraordinary. They help and they find and support. They find doctors, practitioners, and they support the applicants and their families through this process. So often, if there is a conscientious objection, then they'll refer them to a care navigator. Others will not refer them or make any comment. That is a matter for the individual. We have, it's their right. We cannot force them. There's no legislation that can force them to refer someone onwards. It's a matter for them.
And a further question, if a patient was in one of those bed-bound circumstances and they required transport to the beach or their location of choice via some service, such as the ambulance service, I assume. What implications would that have for the service involved?
None at all. It's a legal process. It's perfectly valid. I imagine that in circumstances like that, they probably would not utilise the ambulance. Those people are usually too unwell to even venture forth. We do use ambulances. The patients, so the applicants use ambulances sometimes to get to see the doctors for the appointments, because, as you can understand, specialists in the country are difficult to find. So they will often be taken to and from the appointments via ambulance. And it makes for a very long day.
Yeah. Could we ask, or Greg's asked, does voluntary assisted dying, does that show up on a person's death certificate if they've used that service?
No, it doesn't show up on the illness from which they were dying is what will be on their death certificate, but it will be recorded at birth, deaths and marriages. It just will not be on their birth certificate. On their death certificate.
Yeah. Is there any requirement, Sally asked, for people seeking voluntary assisted dying to undergo a psychiatric assessment?
If there is not a compulsion. The presumption is that, like everyone else, people who are dying are mentally competent. But if there is any concern on the part of the medical practitioner, then they are required to obtain a psychiatric evaluation or refer them for an assessment as to competence and whether or not they are well enough, psychologically and mentally well enough to request this process.
And one more, what is the most significant breach or non-compliance that you discovered in the course of?
Well, so far, I have to say that being predominantly compliant, there have been just inadvertent non-compliance, and it's usually a misunderstanding. We did report this in the report, but I don't want to highlight it. It wasn't that the person wasn't an appropriate candidate. It was a failure to have something witnessed properly. But all of the medical information meant that the applicant was in fact a person who was eligible for voluntary assisted dying. So it was technically, it was a breach in that it should have been witnessed properly, but it wasn't. And that was just a misunderstanding. But we'll see what happens.
I'll move to some of my own questions now, but if anyone wants to keep asking questions, please do. Like we said, we'll try to get back to you. Betty, following on from that last question, are there any cases that particularly stuck in your mind that you've encountered?
Oh, there's a number that stick in my mind. Some that where people have not been able to access it because the process has been delayed or they've started it too late. So I must say to everyone, remember, this is not an emergency procedure. It takes time. These, a young person who died using this was just a terribly tragic case. And there are many, but I don't want, it's very difficult to say too much without doing something that may identify the person, which I certainly don't want to do. Sorry.
I might return to some of these further questions we've been asked. Does your report to the Parliament, do you detail the cost of the system around voluntary assisted dying and what it might be on a per person basis relevant to the number of people involved?
Can I say no, because I don't know what the cost is. We don't control any of the costs. We are a review board. So I'm totally unknown to all of us what it costs, because there are so many steps in the process. It would be hard to work out. You've got private medical practitioners. You've got care navigators, you've got possibly ambulance service involved. It would vary enormously from case to case.
There's a question regarding the portal, and I think you mentioned in your talk. Are there any tips or tricks I think you can suggest on how best to use a portal type structure, or to avoid the most common issues that you came up against?
If you're doing one in South Australia at any stage, come and talk to us.
Okay.
We'll happily tell you about. As I said, someone had to start, and that's what we did. So it was a bit of, well, what do we need? And we've taken the feedback, we've listened, and we realise there are some clunky aspects to it that need to be improved. But the whole substance of the structure will remain there, because that works. It's just we need to make it as user-friendly as possible.
I know our court system has been closely modelled off of your own in Victoria.
Well, good luck with that then.
And can you give us any indications of the length of time the overall process typically takes?
Typically, I'd say between 18 days, probably 2 weeks, 2 to 3 weeks, just for an average type of case. Something where everything's totally in order, you can get it done faster, but people have to find documents, get witnesses. It all takes a bit of organisation. So I would allow at least 2 to 3 weeks. And if people are actually looking at doing this, the best advice I could give is to do it sooner rather than later, because it doesn't matter if you never use that substance. If you just have it there, you can always return it. It's not a problem.
That was actually going to be my next question. I understand it's been reported around 32% of applicants who are approved for the medication don't use them. What is that correct?
Yeah, and it's pretty much a worldwide figure. Surprisingly, it's quite consistent. It's meant. Sorry.
Why you think that is?
That's achieving its purpose, and its purpose is to make the end of life for applicants, for anyone involved, easier, kinder, something that they're not so frightened. For a lot of people, it just means that they've got the substance there, knowing, look, if things get too bad and I'm in dreadful pain and it can't be stopped or it can't be alleviated, I have a choice. And a lot of the comments we get are about people feeling like they've got some control back. A number of applicants and their families talk about the fact that they feel like they've surrendered control to the medical profession, as you do when you are very ill. They calm and they're doing their absolute best for you, but you feel like you're not the one in control anymore. And so many have commented that was like they finally got control back of their own lives, being able to have that, not using it necessarily, but having it there.
And one further question from the audience. Is it likely, do you know, that Victoria will get more care navigators?
We currently have, I think, 6. So we've got, I think we've got 5 in rural areas actually. And they work a day a week in different navigators, but in different rural areas. At the moment, it seems to be enough, but if VAD keeps increasing in numbers, then we'll need more navigators, as we will need more of everything.
I had a similar question or comment, I think, around resourcing. Lauren says, I found patients in rural areas wanting to access VAD take a great deal longer than a few weeks, more like a few months from when they first try and find their first doctor. Difficulties finding participating doctors and issues with getting to them with distance and transport.
Can I say, I understand exactly what she's saying about that. It is infinitely more difficult in the country. The country has less GPs. It has less specialists by far compared to the city. So when you put into that the fact of they also have to be VAD trained, yes, it's infinitely less choice. And the fact that that no one can talk about this, they can't volunteer this VAD as an alternative at end-of-life care, means a lot of people don't find out about it, and the doctors aren't able to bring it up. So it makes it definitely harder for those in the country. And in terms of getting them to and from appointments, the families usually do that, and it must be terrible that they have to get in a car and drive 4 hours for people who were very unwell. So yes, I have no doubt that the country takes longer.
It's something we've been talking about in South Australia too, because Victoria is a fairly centralised state. So here could only be worse, I would imagine.
I keep thinking about Queensland and West Australia and trying to imagine what they're going to do about their rural areas.
Yep. We're nearly out of time, but I'll try and squeeze a few more in if you will. So we've got I'm an aged care nurse in rural SA. The care navigator role sounds interesting. Is it similar to a case manager?
I don't know what a case manager does, I'm afraid. So I'm not the one to ask on that. I'm sorry. What they are, they're enormously supportive, gentle, strong people who just know how to talk to people, know how to assist them. The feedback is, as I say, extraordinary in respect of them and the pharmacists, but particularly in respect of the care navigators. It's just, I've not heard one bad word in terms of the feedback. So if you're involved in nursing, it might be a very interesting role for you.
I think I'll fit one last question in because 2 people have asked it, Betty. In terms of using VAD in a residential aged care home setting, have there been many cases of that? And are there any insights you can offer on how that is different?
There hasn't been a lot of cases, but there have been some. They have been done within the aged care facility, and it depends upon the facility's willingness to cooperate and be involved. But yes, it certainly happened, and it's in the cases where it's been done very well, in that they've ensured that death has been certified and all of those things that have to happen post the taking of the substance in a very good and caring way.
Well, at that point, I'd like to say thanks to everyone who's asked questions. There's been a good spread of them, and we'll get to any further ones. Thank you again, Betty, for your presentation today. Much appreciated.
You're most welcome.
To wrap things up, I would now like to introduce and invite Jane Muzzlered to wrap up today's session. Jane is the Chief Executive of COTA SA, with whom Palliative Care SA have been very pleased to partner for this 3-part webinar series. COTA SA is an older people's movement about promoting the rights, interests and futures of South Australians as they age. In her spare time, Jane acts as the chair of Kids Circus School in South Australia, and is also a board member of the Maggie Beer Foundation. And I might just keep telling you about Jane because I think we're struggling with our camera work. Jane is a past winner of the SA Innovation Award and the Telstra Business Women's Awards, and of a Sanicare Overseas Studies Scholarship to visit aged care facilities in Malta and the Netherlands. Jane has a master's degree in social work, majoring in social policy and research from the University of Michigan. I think I'll leave it there and try to throw over to Jane. Come and sit here, Jane.
You might have to wrap up.
Oh, that's working, Jane. That's working.
Yeah. Hi, Look, I just want to thank Nick for moderating today. It was superbly done. COTA SA is very pleased to be part of this partnership with Palliative Care SA. We're very grateful to Mark Waters and the team here for the opportunity to bring you the webinar series. From our perspective, surveys of older people, including our own national survey in 2018, again, very recently, yet to be published, older people overwhelmingly want the opportunity for voluntary assisted dying as an option. In excess of 80% of the 2018 survey. We share the Palliative Care's view that it's really important as part of that process that we have good conversations well beyond voluntary assisted dying about dying, but including about voluntary assisted dying. And we would welcome your feedback, as does Palliative Care SA. By all means, give it to us. Mark Waters can be contacted at mwaters@palcare.asn.au, or me, jmuzzard@cotasa.org.au. Betty, mostly I want to thank you. It's an extraordinary thing to be a pioneer in a very, very sensitive area. That takes a lot of courage. We thank you very much for your conscientious presentation today, to share your knowledge, to share your experience, and to be generous in doing that, offering not only the benefit of the things that have gone well, but the things that can be improved is extraordinary. Like others here, I have to say we feel for our colleagues in Victoria and send our love, and hope that this lockdown is very soon over for you. So thank you all of you for participating. This is a very critical time for us in South Australia in terms of considering this legislation. And thank you most of all to our Care SA. Thanks.